Why is it who gets behind the wheel and kills gets to live, and the innocent die, and the innocent were killed by him?
Windshield and dashboard so hard that her brain was exposed. Her nose was crushed, her pelvis and both of her legs were broken.
You murdered your girls. I hope somebody gets their hands on you and hurt you.
Darla Renee Jackson pleaded guilty to voluntary manslaughter following a road rage incident that resulted in the death of U.S. Navy Chief Petty Officer Zacharias Buab.
103-29-30.
The confrontation began when Jackson, driving at high speed, passed closely by Buab, who was on his motorcycle. In response, Buab kicked her car door. Jackson then followed him closely until traffic slowed, leading to a collision that proved fatal.
And she hunted him down.
In court, Buab's family shared their grief, bringing a portrait of him as they spoke about their loss.
He taught me so much. And he's gone. And I miss him.
Jackson, tearful and remorseful, addressed the courtroom, saying,
Not a day goes by that I don't relive and regret what happened. I know there isn't anything I can do or say that can take the pain away, but I know that the Lord can. I pray that God will heal the pain.
The prosecution argued that Jackson's actions were reckless, while the defense maintained that the crash itself was unintentional.
The accident itself was an accident.
The judge acknowledged that while the impact may not have been deliberate, her decisions leading up to it were reckless.
Justice to me was not served.
We couldn't have gotten through this. And I want to just say thank you for everybody that's helped us through this.
Following the verdict, Buab's family expressed disappointment, feeling that justice had not been fully served.
The accident itself was an accident.
I would still arrive at the 6-year term, and that is what I'm going to do. I'm going to commit you to the Department of Corrections, Ms. Jackson, for the middle term of 6 years for the reasons I've stated.
Although there were discussions about alternatives like counseling and probation, the court ultimately ruled in favor of incarceration. Jackson was sentenced to 6 years with credit for time already served. In January 2013, Hadiya Pendleton was tragically shot and killed in Chicago's Harsh Park, shortly after performing at President Barack Obama's second inauguration.
Someone came in and said that she had died.
Her mother vividly recalled the moment she received a devastating phone call. An officer initially reassured her that Hadiya would be okay, but when she asked to speak with her daughter, she was told Hadiya was already in the ambulance. Fighting back tears, she later testified in court, pausing before softly answering no when asked if she ever saw her daughter alive again.
I was talking to the officer, and the officer was trying to assure me that Hadiya was going to be okay, and then I asked if I could talk to her, and the officer said, no, she's already in the back of the ambulance, and that she was alive and well.
The investigation led authorities to 2 suspects, Mikhail Ward and Kenneth Williams. According to the prosecution, Ward and Williams mistakenly believed they were targeting rival gang members when they fired into a group of boys. Surveillance footage from the park showed people running for safety in the aftermath. Chicago Police Sergeant Velma Guerrero testified that ongoing gang conflicts, security footage, and witness statements helped investigators identify Ward and Williams. One key witness, Veronica Hansberry, picked them out in a police lineup, though she admitted some uncertainty regarding one of them.
After viewing the lineup, witness Veronica Hansberry informed Detective Guerrero that the subjects in position number 2 and number 4 resemble the shooter. This is a tentative identification on subject number 2, Michael Ward.
Forensic scientist Mary Wong examined a vehicle seen in the surveillance footage, which was allegedly connected to the suspects. However, no gun residue was found. In 2018, Ward was convicted of first-degree murder and sentenced to 84 years in prison. However, in 2023, an appellate court overturned his conviction, citing concerns over how his confession was obtained. In early 2025, the Illinois Supreme Court upheld this ruling, granting him a new trial. Williams was also convicted in 2018 and later sentenced to 42 years in prison. Yaser Said was found guilty of the capital murder of his daughters, Sarah and Amina Said, in a case that took years to reach trial. The prosecution argued that Said, originally from Egypt, was furious that his daughters were dating non-Muslim boys. A critical piece of evidence was a 911 call from the night of the crime, in which Sarah named her father as the attacker before succumbing to her injuries. Following the murders, Said went into hiding for over a decade before authorities finally captured him. During the trial, his ex-wife, Patricia Owens, took the stand, describing years of alleged abuse and control. Holding up photos of her daughters, she expressed the pain of losing them and the milestones they would never experience: graduation, marriage, and motherhood.
Yaser Said, you're a devil. You murdered your girls. And I'm gonna say this. I hope somebody gets their hands on you and hurt you and do everything you ever done to anybody. That's counting the 9 bullets you put in Sarah, 9. And she called 911. Amina, 2 bullets in the heart. You could keep those evil eyes glaring, just glare away, because this is going to be the last time that you see me.
Prosecutor Lauren Black described Said as a narcissist who believed he was smarter than everyone else. She was satisfied that he chose to testify, as it allowed her to cross-examine him and expose inconsistencies in his defense.
We, the jury, unanimously find the defendant Yaser Said guilty of the offense of capital murder as charged in the indictment.
After deliberating for 3 hours, the jury delivered a unanimous guilty verdict. The judge then sentenced Said to life in prison without the possibility of parole. Said's son, Islam, and brother, Yasin, were also convicted for aiding his evasion. Islam received a 10-year federal sentence in April 2021, while Yasin was sentenced to 12 years in June 2021. In Las Vegas, Krista and Damaso Puente were tragically killed when their vehicle was struck by Henry Aparicio. The couple had stopped at a red light at the intersection of Sahara Avenue and Hualapai Way when Aparicio, driving under the influence at nearly 100 miles per hour, crashed into them. The impact was devastating, and both lost their lives at the scene. In the wake of the tragedy, Krista's mother expressed her frustration in court.
Why is it that also often the one who gets behind the wheel and kills gets to live and the innocent die? The defendant is guilty and the innocent were killed by him. Why did he do this to them?
Krista's parents questioned why he chose to drive drunk.
I think about all the what-ifs of that day.
Why? Why? Henry Aparicio, why?
Krista's father, Daniel Malone, remembered his daughter's kindness and warmth.
You destroyed her body, but you couldn't destroy her loving soul.
He described the pain of losing her so suddenly, comparing it to a candle's flame being extinguished, leaving behind an overwhelming emptiness.
I think about her body being thrown against that windshield and dashboard so hard that her brain was exposed. Her nose was crushed, her pelvis and both of her legs were broken. He disfigured my little girl so badly that we couldn't say goodbye to her one last time.
He has ruined so many of our lives. I'm sorry.
Like someone blowing out a candle, whatever joy and happiness I've had in my life has been utterly snuffed out by Henry Aparicio.
I shouldn't have to talk to their grave and weep and tell them how sorry I am that this happened to them.
Aparicio was charged with 2 counts of DUI resulting in death and felony reckless driving. In his 2019 trial, he pleaded guilty and apologized to the victims' families and his own. Despite his remorse, Krista's parents urged the judge to impose the maximum sentence. The court sentenced him to 15 to 44 years in prison.
But I really honestly am thankful that he's gotten this sentence because that's pretty much the most we could have expected for today.
Determined to prevent similar tragedies, the Puente family also advocated for stronger DUI laws, highlighting that Nevada law only allows vehicular homicide charges after 3 prior DUI offenses. Meanwhile, Aparicio appealed his sentence, arguing that the court improperly considered victim impact letters. In 2020, the Nevada Court of Appeals ruled in his favor, granting him a new sentencing hearing. However, in 2022, the court upheld the original sentence. Ayanna Council caused a devastating crash on Highway 58 that took the life of 52-year-old Michelle Rodrigue. Rodrigue, a recently retired school crossing guard, was traveling with her husband to their new home in Las Vegas when Council, driving under the influence, collided with their vehicle. Investigators revealed that Council's blood alcohol content was 0.22, 3 times the legal limit. This was not her first offense, as she had 2 prior DUI charges in San Mateo County and Las Vegas. In court, Council expressed deep remorse, offering an emotional apology to Rodrigue's family.
I don't deserve to live.
Don't say that.
Why should I deserve that? Let Pat do what she can. Why should I be free? Michelle may be free spiritually, but her family won't be free to talk with her, free to hear her laugh, free to walk with her, free to just be around her, feel her hugs, her essence in the air.
Despite their pain, the family and those present in the courtroom showed compassion, recognizing the tragic consequences of impaired driving. Following the trial, Council was found guilty of second-degree murder, gross vehicular manslaughter while intoxicated, and multiple other charges. The judge sentenced her to 15 years to life in prison under California's indeterminate sentencing law, allowing for the possibility of parole. A girl was sentenced to 7 years in juvenile prison for stabbing her mother. This tragic incident occurred in December of 2023 in San Antonio, Texas, when Bexar County Sheriff's deputies responded to a call at a home on the northwest side and found the 33-year-old mother with severe, life-threatening injuries.
I'm not sure what happened that day. I'm not sure what happened with you in the back for you to be the perfect angel back there. Something is not right about this whole situation. And I don't think it came to light.
Kimberly Thomas, assistant supervisor at the Restore Hope unit, took the stand to explain the details of the case. She testified that she had been meeting with the girl weekly while she was in detention, working with the family to gather information. According to Thomas, the girl became upset with her mother while she was cooking, struck her on the head from the back, and stabbed her. Despite this, the mother survived the attack. The girl was taken into custody and charged with aggravated assault of a family member. In October 2024, the girl was sentenced to 7 years in juvenile prison for the attack. The judge noted that she had no prior incidents during her time in detention and advised her to seek help and education during her sentence. In Holly Hill, South Carolina, a tragic case unfolded when 4 individuals, Jerome Butler, Crystal Hutto, Tamara Perry, and Shemekia Sanders, were found dead in a residence on Old State Road. Dreams Nelson was also injured, but survived. Authorities believe the incident was linked to drug-related activities involving the victims' families. The investigation led to the arrests of Antley Jermaine Scott, Luther Smith, and Robert Bailey.
Your Honor, my motion is to dismiss these horrible charges on the grounds of lack of probable cause. As Your Honor knows, probable cause is based upon, it's defined, legally defined as, is there a reasonable basis in the facts to believe that a crime has been committed and that the person charged before the court is the one who committed the crime. That's the legal definition of probable cause. In this case, the prosecution has now admitted through its own witness that they do not have the typical evidence that one would expect in a murder case. There is no confession. There is no DNA. There is no residue. We understand the time factor about that. There is no gun. Therefore, there are no ballistic tests. There are no fingerprints. They have no physical evidence. And the bottom line is they essentially have no case. And when you look at all of the insufficiencies of evidence and the things testified to by this officer, the fact that the man who's given the statement He's trying to save his own neck. He admits that he was there, he admits that he was involved, and now he ties in Mr. Scott. I think it's sort of a fallacy to believe that he, Mr. Smith, could not have communicated with Mr. Coleman while Coleman was in Alabama. And the fact that Coleman and my client, Mr. Scott, were together, there's nothing about that indicates criminal activity. There's nothing against the law to go to Alabama. There's nothing against the law to go to Alabama with anybody for that matter. But the point I'm making is, I think they failed to establish probable cause, and since the evidence is insufficient as a matter of law, I move the court to dismiss these horrible charges.
During the court proceedings, Scott's attorney, Carl B. Grant, argued that the case lacked physical evidence, pointing out that there was no DNA, weapon, gunshot residue, or ballistic tests. He also questioned the credibility of a key witness, claiming the individual was trying to shift blame to reduce his legal consequences.
This is a case where we have two individuals that independently corroborate each other, that both implicate Anthony Scott as being one of the individuals involved in this. I think that right there, is enough probable cause. We have one of them that comes forward, that is arrested, and gives a statement implicating Anthony Scott, also implicates Derek Coleman, which leads to arrest warrants being issued for the two of them. They are found together in another state. And then his roommate then gives a statement that basically corroborates what that prior co-defendant said, yet again implicating Anthony Scott. I think that right there is probable cause and enough to go, not only to bind it over, but I submit enough. It's ultimately going to be a jury issue as to the credibility of those two witnesses. But I would submit it would be enough to convict him, let alone just establish probable cause.
The prosecution countered by presenting statements from two separate witnesses who independently identified Scott as one of those involved. One of them, after being arrested, provided information linking both Scott and another suspect, Derek Coleman, which led to their arrests in another state. A second witness later corroborated this testimony, reinforcing the case against Scott.
All right, based on what I'm hearing, I do feel that the state has met its burden of proof of probable cause. Probable cause, of course, sometimes the little minute details that puts you over the fence of getting what you got to get. It is a matter of fact for the jury to decide. It is a matter of, not a fact of law at this particular point. It's a fact of presenting the evidence for the jury to consider, the fact finders to consider. So I do feel that probable cause has been met, and I am going to send this case on the general session for adjudication. Thank you very much.
Thank you.
After hearing both sides, the judge ruled that the prosecution had established probable cause. The judge allowed the trial to proceed. In the final verdict, Scott, Smith, and Bailey were convicted and sentenced to life in prison for their roles in the case. Derek Coleman, who was initially charged alongside them, testified for the prosecution, stating that Scott had confessed to the crime. Due to his cooperation, Coleman was not tried alongside the other defendants. On the evening of August 24, 2023, a devastating crash occurred in Jacksonville, Florida. Orlando Lopez Vasquez, 40, was driving a Ford F-250 in the wrong direction on Hartsfield Road. Witnesses said he sped through a red light, crashing into a Honda Fit at the intersection with Merrill Road. Inside the Honda were 4 family members: Roberto Ramirez, his wife, Yahil Perez, his mother-in-law, Maria Elena Hernandez, and his nephew, Oscar Rolando. The impact was catastrophic. Yahil and Maria died at the scene, while Oscar passed away later at the hospital. Roberto survived but suffered serious injuries. When officers arrived, they immediately noticed signs of intoxication. He admitted to drinking earlier in the day. A blood test revealed his blood alcohol level was more than twice the legal limit. This wasn't his first offense. Back in 2020, Vasquez had been arrested for DUI after nearly hitting a state trooper. He was sentenced to 6 months of probation and a brief jail term. Following the crash in August, Vasquez was taken into custody.
Right. As far as I know, he's the only one that needs an interpreter. Sir, you were here on 3 counts of DUI manslaughter.
Señor Orlando Vázquez López, usted se encuentra aquí por 3 cargos de conducir en estado de ebriedad, homicidio culposo, ocasionando muerte a terceros.
2 counts of DUI with property damage or personal injury.
Dos cargos por conducir en estado de ebriedad, por ocasionar daños y o lesiones a terceros,
and 1 count of DUI.
He faced multiple charges, 3 counts of DUI manslaughter, 2 counts of DUI with property damage or injury, and 1 count of DUI.
Did the state or defense wish to be heard on bond?
Yes, Your Honor.
Señora fiscal, señor defensor público, ¿desea aportar algo en referencia a la fianza monetaria? Sí, señoría.
At this time, the state files a motion for pretrial detention and respectfully requests the court take judicial notice of case 2020 CT 1789.
Sí, señoría. Nos gustaría darle aviso jurídico de la causa 22 CT 1705.
Mr. Maurice, does the defense wish to be heard?
Nothing from the defense, Your Honor.
Licenciado, abogado de oficio, defensor público Maurice, ¿necesita aportar algo? Nada por el momento, señoría.
All right, for the record, the case number that the state cited to appears to be a prior DUI that this defendant committed.
Para que conste en acta, la causa suya del año 2022, CT 1705, es el cargo anterior por lo mismo, por conducir en estado de ebriedad.
Based on that, I will grant the state's motion for pretrial detention as to the 3 DUI manslaughter counts.
En base del antecedente citado por la Fiscalía, la prisión preventiva queda decretada por los nuevos cargos de conducir en estado de ebriedad, homicidio culposo, ocasionando daños y lesiones a terceros.
Do the state or defense wish to be heard on the remaining counts?
Yes, Your Honor, for the remaining 1, 2, 3 DUI counts, the state would recommend $250,003 for each.
Y señora fiscal, referente a los demás cargos por conducir en estado de ebriedad, por el primero, segundo y tercero cargo, la Fiscalía recomienda una fianza de $250,000 y $3 por cada uno de los cargos.
And Mr. Maurice, does the defense wish to be heard?
No, Your Honor, not at this time.
Señor Maurice, la Defensoría Pública desea manifestar algo en este momento, no, señoría.
For the remaining 3 counts, I'm going to set bond in the amount of $500,003 on each count.
Por los remanentes 3 cargos por conducir en estado de ebriedad, la fianza monetaria queda fijada en $500,000 y $3 por cada uno de los cargos.
Order a scram monitor.
Si logra salir en libertad bajo fianza monetaria, tendrá que tener un dispositivo que controla si usted consume vicios o alcohol.
No driving.
Queda prohibido de conducción.
And no drugs or alcohol.
Y queda prohibido de consumos de cualquier droga, tóxico o bebida alcohólica.
I'll appoint the Public Defender's Office to represent you.
Le nombro el abogado de oficio, el defensor público municipal para representarle a usted en esta causa.
And pass your case to September 14th at 9 o'clock in Circuit Court.
Y aplazo su causa ante el Tribunal de Primera Instancia por delitos mayores el 14 de septiembre a las 9 de la mañana.
In court, a Spanish interpreter was brought in to assist. The prosecution requested pretrial detention, citing his past record. The defense offered no objection. The judge set bond at $500,000 for each manslaughter charge and $250,000 for the DUI. Vasquez was also ordered to wear an alcohol monitoring device and banned from driving or consuming alcohol and drugs. On September 21st, 2023, Vasquez pleaded not guilty to all charges during his arraignment. As of the latest update, he remains in custody, awaiting trial. Roberto Ramirez, the lone survivor in the Honda, continues to recover. He and his family have called for justice, hoping that no one else has to endure such a tragedy. Stuart Richardson had a long history of driving offenses, accumulating multiple convictions over the years. Despite appearing before 22 different judges, he had never been sentenced to prison. That changed following a tragic incident that altered a family's life forever.
Justice system in this country and those other states has played catch and release with this man for too long. He has stood before 22 judges, but he's never had judgment for what he's done.
In 2009, Richardson, under the influence, collided with a family's vehicle in Arlington, Texas. Among the passengers was Abdallah Kader, who suffered severe injuries. The crash left him in a vegetative state, and for 6 years, his family cared for him, hoping for a miracle. Sadly, in 2015, Abdallah passed away. The legal battle that followed was long and painful. In court, Abdallah's family spoke about the devastating impact of the tragedy.
I already did forgive you, and I have nothing to do with you after today. But wake up that conscience, get closer to God. Ask Him for forgiveness. Ask Abdallah for forgiveness.
And Mr. Richardson earned every day of that 50-year sentence. 22 prior convictions, 6 of them for alcohol-related offenses, 3 people seriously injured over 2 decades ago. If there's anyone who's earned time in prison, it's him.
Well, I hope what we did today, we got justice for the families that Stuart Richardson hurt before. My son, I don't think there's anything that can be done to get us justice for him. And I hope it raises awareness about drunk driving.
Despite their grief, they emphasized their desire to honor their son's memory while moving forward. Prosecutors pointed to Richardson's extensive history of reckless behavior, highlighting that 6 of his previous convictions were related to alcohol offenses. They argued that his repeated offenses and the legal system's previous leniency had enabled him to continue driving under the influence.
Find a deadly weapon to be true and assess a sentence of 50 years confinement in the Texas penitentiary.
For the first time, Richardson faced real consequences for his actions. He remained emotionless as the verdict was read, while his attorneys declined to comment. The Kader family, however, felt a sense of closure. Richardson was sentenced to 50 years in prison. Heather and Melissa Gartner, a legally married lesbian couple, fought for the right to have both their names listed as parents on their daughter's birth certificate. Their legal battle eventually reached the Iowa Supreme Court after the state appealed a previous ruling in their favor.
We believe that Mackenzie deserves all the respect like any other child. It would just make our family complete.
The Iowa Department of Public Health had initially denied their request, arguing that Melissa, as a non-biological parent, could not be listed. This led the Gartners to file a lawsuit, bringing the case before the Iowa Supreme Court.
And the spousal presumption has always meant that the spouse of a birth parent is a parent by establishment of law, by operation of law. They are an established parent. And this holds true even when the spouse is not the genetic parent of the child.
Camilla Taylor from Lambda Legal represented the Gartners, while Deputy Attorney General Julie Pottorff argued the case for the state, claiming the department was simply following Iowa law.
If a mother was married at the time of conception, birth, or at any point between conception and birth, the name of the husband shall be entered as the father on the birth certificate.
The two sides had different interpretations of the law, which raised questions for the justices to consider.
Why wouldn't they be differently situated for purposes of the marriage statute generally?
Is it a statutory interpretation or is it a constitutional decision?
Both sides awaited the court's decision, knowing the case was significant, not just for them, but for other lesbian couples across Iowa.
It means I never have to worry about things that you don't even think of when you're a parent, like registering your child for school or an emergency pickup from school. I mean, if you're not listed as, the parent, there are things you can't do.
While both sides were confident in their arguments, neither was willing to predict the outcome. In the end, the court ruled in favor of the Gartners, marking a victory for their family and others in similar situations. In the late 1990s, Stanley Watson served as a staff member at New Hampshire's Youth Development Center, now known as the Sununu Youth Services Center, located in Manchester. During his tenure, Watson exploited his position to sexually assault 2 boys under the facility's care. He manipulated these vulnerable boys by offering special privileges and attention, grooming them to satisfy his predatory desires.
CS and AC, 14 years old. That's a vulnerable age in and of itself. But they were much more vulnerable than an average 14-year-old child. They were both physically small-sized boys, approximately 110 pounds and approximately 5'6" tall. They had both been diagnosed with learning and cognitive disabilities before they encountered the defendant. They were both physically and emotionally separated from their families at the time they encountered the defendant. They were both subjects of the defendant's custody and control because the defendant was their night shift correctional officer. The defendant was a man who had the authority to control all aspects of their lives. He could award them privileges, or he could impose significant punishments. The defendant was a man whose word would not be questioned by any other staff members or supervisors. What he said happened, happened. What he said didn't happen, didn't happen. The defendant worked the overnight shift when there were no other staff members around. Alone, he walked through the darkness of the hallways of Spalding Cottage and Stark House, lurking in the shadows, watching the children in their bedrooms, and selecting his victims. Once he chose CS and AC as the objects of his desire, he began grooming them so that they would submit to his coercion, to submit to his assaults without telling anyone what he was doing to them. He groomed them by giving them things they were not able to get anywhere else. Things that may initially sound insignificant to those of us that are accustomed to them, but things that meant the world to kids like CS and AC. Things like soda, chicken wings, steak and cheese subs, extra privileges, and sadly, something as simple as kindness from an adult. And then, behind closed doors, behind locked doors, in CS's bedroom in Spalding Cottage, and in the linen closet at Stark House with AC, I use the term fellatio only for the purposes of this record, because that is what the statutory language refers to. But the word fellatio is too sanitized for what the defendant actually did here. Here, it's more appropriate to use an anatomical description of the defendant's crimes. The testimony at trial, which the jury credited and found true beyond reasonable doubt, revealed that the defendant did this to both children on multiple occasions.
The victims, now adults, endured lasting trauma from these assaults. They became addicted to drugs to cope with the trauma and even served time in prison.
As I'm sure the court will remember, during AC's testimony, AC used a phrase that I won't repeat here again today because of the vulgar nature of the phrase. But it was a phrase to describe the violent nature of the way that the defendant repeatedly and forcefully inserted his penis into AC's mouth the night that AC tried to end the defendant's use by reporting it to the house leader, a child whom the adult had authority over, and did this to the child while threatening to abuse that authority to punish the child if he didn't submit to the defendant's pleasure. I've heard people use the phrase "children are resilient" when referencing a child's ability to adapt to new, unexpected, and challenging situations that they might face in life. And to a great extent, children are resilient. But no child, no matter how emotionally strong, could be resilient enough to persevere the abuse the defendant perpetrated upon CS and AC without incurring significant psychological damage. And significant damage resulted here. The court saw that damage in the testimony about the resulting paths that both CS and AC's lives took after they aged out of the YDC. Rather than being in a better position to reenter society, because of what the defendant did to them. While they were there, they were returned to society in a much worse position than they would have been had they never encountered the defendant. Both tried to suppress the emotional and psychological damage from the defendant by abusing powerful and dangerous drugs. Both have engaged in significant criminal conduct to support their addictions. And as a result, both have been incarcerated for significant periods of their lives. The court heard AC tell us that he'll always remember the sound of the engine of the defendant's black Mustang, because he could hear it from his bedroom window at night when the defendant arrived at work. And because hearing that noise meant that he knew that he would be sentenced again before the morning staff arrived. And the court heard about how CS was, and still to this day is, confused about himself and his sexuality, about how he still to this day blames himself for participating in the sexual abuse perpetrated against him by the defendant. In preparing this case for trial, the state met with AC and CS on as many occasions as we could to help them become more comfortable talking about what the defendant did to them. And it wasn't easy for CS or AC to talk with the small trial team in private about the sexual acts that the defendant forced upon them 25 years ago when they were children.
One victim testified that Watson continued the abuse even after becoming his foster parent, highlighting the profound betrayal and manipulation involved. In January 2025, Watson was convicted on 3 counts of aggravated felonious sexual assault. During sentencing, victim impact statements were presented to the court. One of the victims, unable to attend in person due to the emotional burden of the trial, had his statement read aloud by a victim advocate.
Good afternoon. I will be reading an impact statement for CS. Stan, I've started this letter and threw it away 3 times. Not for your benefit, but I'm just trying to convey the thoughts and anguish I have in my head and my heart towards you without being kicked out of this courtroom. What you did to me is more than confuse me. It was more than making me feel important, like I was wanted and not alone in such a hell of a place. I hate you. I hate you for all of you done and all the mental damage I deal with on a daily basis. I pray every night the judge gives you what you deserve. I have to look in the mirror every day, and the nightmares come weekly. I know God wants me to forgive you like he did for me, but I'm just not there yet. You are a monster, and the only place that is good for you is hell, but prison will do. I want every night for the rest of your life to be a reflection of the damage you have done to me. I've wasted too much of my time on you already. I'm done with you, and now I'm building me back. Judge, please put him where he belongs for the rest of his miserable life, in prison.
In his letter, he described years of psychological distress, including recurring nightmares that continued to haunt him. His words reflected both pain and unresolved anger. He went on to say that he hoped Watson would spend his time in prison, remembering the harm he had inflicted. Another survivor did attend the sentencing and faced Stanley Watson directly. With unwavering emotion, he referred to Watson as evil and the devil.
I was 14 years old, had learning problems, had trust issues, had no family that loved me. I was scared being in YDC at a young age. I moved to Stark House. I met you, Stan Watson. You were kind at first. I thought you were going to be my friend and keep me safe. How wrong I was. Instead, you started to molest me, and I didn't understand what was going on. I was naive, and I let you take advantage of my innocence. And when I didn't want to do it anymore, and I spoke up to Jim Peace, he told me he was going to look into the situation. He ended up telling you about it, and you got mad. You brought me into the same linen closet you would use every night to molest me, and you got very mad, and you beat me, and you told me that no one will ever believe a thing I say, and if I say anything about you beating me, first, no one will believe me, and you would handcuff me and bring me to King Cottage, where you would say I tried to escape. So you put the fear of God in me, so I never refused when you wanted to molest me. I was scared every night when I knew you were working. I used to hide under my blankets. You would back your black Mustang up to my window, and I would know I was about to be taken to the linen closet where you would have your way with me, and that messed me up a lot. When I grew up, I struggled with relationships. I couldn't trust no one. I started to use drugs to deal with the pain, to bury it so deep so I didn't feel it. I didn't talk to no one about what you did to me because you had me brainwashed with fear. So I had a hard time in school and ended up in the system, in and out of institutions because of my trauma caused by your hands. All I wanted when I was a kid was someone to love me and be there for me, to show me how to fish and hike. I finally got enough courage to speak up, and I was believed. The very thing you told me no one would ever believe me. You had that instilled in my brain when I was on the stand telling the juries what you did to me, which was very hard for me to do. You were over there at the defendant's table smirking and grinning at me and laughing. I don't see anything funny about what you did to me. It's actually sick and sad. You are a predator, and you deserve never to see the light of day again. Your Honor, I ask that when you are considering Stan Watson's sentence, that you take into consideration that he abused his power to groom young boys and molest them for years, and got away with this for 26 years. I ask you to please give him the maximum sentence that his crime allows for. Stan Watson, you don't have control over me anymore. I am strong. I am clean. I have been clean for 3 years now. I have a beautiful daughter and a son. I have given my life to God now, and part of my recovery is I need to forgive people that have done me wrong. And I am trying to get there, but I am not there. You hurt me so bad, it's going to take a lot to get there. I leave it in God's hands. You are evil, you are the devil, and you belong in hell. Thank you, Your Honor.
He revealed that he had once tried to report the abuse to other staff members, but instead of helping, they informed Watson. In retaliation, Watson assaulted him again and threatened to falsely accuse him of trying to escape, warning that no one would believe him. His statement highlighted the deep trauma and fear he endured, as well as the failure of the system meant to protect him.
And you may be aware, or maybe you're not, but last week I sentenced Bradley Asbury to the maximum sentence allowed by law as being an accomplice to aggravated felonious assault of one resident at King Cottage. And while his actions in that case I described as sadistic, in many ways your conduct is far worse. Assault of a minor is a bad enough crime in and of itself, but the context of this case and what you specifically did to these two boys make this vile crime even more unthinkable. A, C, and CS were vulnerable adolescent children. You pretended to be their friend when they had no other friends in their life, to give them privileges, to treat them with special attention that they never experienced from another adult, only to take advantage of that trust for your own selfish sexual gratification. You controlled everything about these boys' lives. Where they ate, when they showered, when they slept. They couldn't even go to the bathroom at night without your permission. And they were literally your prisoners, and you were their guard. And you knew that because they were wayward children, no one would believe them. And that gave you power and control over them that this court rarely sees in any other type of assault case. And when CS rebuffed your initial advances, you punished him by cutting off those privileges that you were giving him. And then when you approached him again for sex on a second occasion, he knew the consequences if he resisted your advances. And if that isn't grooming, then I don't know what is. And because of your abuse of authority and the crimes that you've committed in your capacity as a government employee, your actions add a dimension to these crimes that this court has not seen in any other case. So even though the full punishment authorized by law doesn't come close to meting out justice in this case, Any lesser sentence would send a message that there is some mitigating circumstance or factor in this case that simply does not exist. And so with that, I'm sentencing you to 30 to 60 years in the New Hampshire State Prison. Stand committed. 10 to 20 years on each of the convictions, consecutive to one another. Each of these sentences are, as I said, stand committed, fully stand committed. I'm not suspending any portion of them. Because they are fully stand committed sentences, the recommendations of no contact with AC and CS and the recommendation you participate in sex offender treatment are mere recommendations to the Department of Corrections. So you're remanded to the custody of the sheriff.
During sentencing, Judge William Delker emphasized the severity of Watson's actions, stating that his conduct was far worse than other cases, given his calculated grooming and exploitation of the victim's trust. He was sentenced to 30 to 60 years in the New Hampshire State Prison. This case is part of a broader investigation into the YDC, where over 1,100 former residents have alleged physical, or emotional abuse spanning 6 decades. Watson's conviction underscores the systemic issues within the facility and the enduring impact on its victims. On the morning of September 2nd, 2022, Eliza Fletcher, a beloved kindergarten teacher and mother, went out for her usual jog near the University of Memphis. When she didn't return home, concern quickly grew, and her family reported her missing. Surveillance footage later showed a dark SUV pulling up beside her. A man stepped out, forced her into the vehicle, and drove off. The kidnapping was quick but violent. Police launched a massive search, and clues began to surface. A pair of sandals found near the scene contained DNA that matched Cleotha Abston, a man with a prior conviction for kidnapping. Authorities located his SUV and arrested him on September 3rd, charging him with aggravated kidnapping and tampering with evidence. On September 5th, the search ended in tragedy. Police discovered Eliza's body behind a vacant house in South Memphis. With confirmation of her death, Abston's charges were upgraded to first-degree murder and other related offenses. On September 7th, Cleotha Abston appeared in court for a bond hearing.
Based upon the new charge, Mr. Henderson, you're now charged with first-degree murder. I did advise you yesterday concerning the other charges, especially aggravated kidnapping, tampering with or fabricating evidence in a criminal case. The bond in that case was set at $500,000, and now in this case, the state has filed, and you are charged with first-degree murder. So in light of the change of circumstance, with the additional charge in that case, first-degree murder, I'm going to order that there be no bond. The $500,000 bond will be revoked pending a hearing for bond. And to have a proper lawyer represent you on that, in light of this case's issues that were raised, which I will not go into until I can resolve them, hopefully by tomorrow, and see about another lawyer for you if necessary. First, I have to make a ruling on the motion filed by current defense counsel. So the status of the case will be that your cases, Mr. Henderson, are set for tomorrow, which is September the 8th. On the first case, the record 220182222, on the additional charge having been filed in that case of first-degree murder, there will be no bond set pending a hearing for a bond. A hearing on that bond. No bond. In the second case, 220182270, on the charge involving theft, identity theft, and fraudulent use of a credit card, there will be no bond set in that case. So the defendant held without bond pending a bond hearing with counsel. I'll try to resolve these issues as quickly as possible.
The judge revoked his previous $500,000 bond and ordered him to be held without bail, citing the new first-degree murder charge and public safety concerns. His legal representation was also brought into question. Issues were raised about whether his current defense attorney should continue on the case. The judge requested additional records before deciding whether a new attorney should be assigned and scheduled a follow-up hearing. Abston also faced unrelated charges involving identity theft and fraudulent use of a credit card, for which he was also held without bond. Court records revealed that Abston had a violent past. He had kidnapped a Memphis attorney and served 20 years in prison before being released in 2020. In a separate case, Abston was found guilty in April 2024 of the 2021 rape of Alicia Franklin. He was sentenced to 80 years in prison for that crime.
This is, effectively a life sentence for Mr. Abston given his present age. This is a maximum sentence that we could ask for, and this is a maximum sentence that the judge could give him.
Abduction and murder of Eliza Fletcher. Mr. Abston plead guilty under that indictment.
On October 28, 2024, Abston pleaded guilty to the first-degree murder and especially aggravated kidnapping of Eliza Fletcher. He was subsequently sentenced to life in prison without the possibility of parole. In February 2016, retired optometrist Terry Sanderson joined a ski group at Deer Valley Resort in Utah. It was a clear day on the slopes, and he recalled staying to the right side of a beginner run to avoid crowded areas. As he was making smooth turns, Sanderson said he suddenly heard a scream from behind, followed by a hard impact to his back that knocked him into the snow. He claimed he was struck, and when he came to, he was lying motionless, disoriented, and unable to move. He heard a voice yelling at him, but couldn't see who it was.
And it was wide open. There was nothing in front of me. And so I came around that corner, and it takes my breath away to think this is hard, because I don't like going through this scene. I just remember everything was great, and then I heard something I've never heard at a ski resort, and that was a blood-curdling scream. I can't do it. It was, ah, and then, boom. And it was like somebody was out of control and gonna hit a tree and was gonna die. And that's what I had until I was hit.
That's what was going on in your mind.
Overruled?
That's what's going on in your mind when you hear that scream.
That was instantaneous. Oh my gosh, somebody's out of control. And they're really seriously out of control. Not time for a hockey stop. I didn't go think about that, but most people could avoid that, I think. Good skiers.
Okay. And I'll move on.
Okay.
So you.
All right, I need overruled.
He's overruled.
Okay, thank you. So you hear this scream.
Yes.
What happens next?
I got hit in my back so hard, and I'm right at my shoulder blades, and it felt like, and was perfectly centered, and the fists and the poles were right there at the bottom of my shoulder blades. Serious smack. Never been hit that hard, and I'm flying. I'm absolutely flying.
Now, you're not airborne.
Well, all I saw was a whole lot of snow, and I didn't see the sky, but I was flying in that sense. I had no control. And I remember this thinking, okay, you really got to hang on. And then I thought about the crowd on the left, and I thought, I don't know who's wanted over there, and I do not want to get them mixed up in here. And I've heard, that maybe that's not decided about how my ribs really got hurt. I absolutely lurched with what little I could off of my skis a little bit more to the right to make sure nobody over here got involved on my left side. And then it was like the ground's coming up, nobody in front of me, just me going to the ground, and you're falling far further than 90 degrees like you'd fall on a floor. You got that extra, and so it's quite a ways to hit the ground. And I just said, okay, you got to protect your face, and your head, and that's the last thing I remember. It didn't happen. I did glance over and saw just just out of the corner of my eye, I could see, not glance over, but I could see somebody going by, and I'm going, okay, they're safe. Last thing I remember, everything's black.
Did the person who struck you land on top of you?
I wouldn't know that. I absolutely would not know that. I was just surprised. I had no upper body strength enough to be able to catch myself. I had no idea.
Do you remember hitting your head on the ground?
No, that part, no, that's all gone. I just remember my arms collapsing, and that's the last thing I remember.
What's the next thing you remember?
I'm getting an adrenaline rush here, I guess, living this again. Just being here and present, too.
And let me just stop you really quick. You said you're getting an adrenaline rush. Is this something that you enjoy?
Adrenaline rush? Not this kind.
Yeah.
Not now.
Okay. All right. So what's the first thing that you remember? Or the next thing that you remember after you're on the ground?
The first I remember is everything is still black, like I'm unconscious. But it's like my subconscious is going into protection mode, like, you better pay attention here and listen to what's being said to you. And all I could recognize was that someone was really angry at me. And it was a man, and it didn't come out clear in the beginning. I couldn't really hear what he was saying, but I just knew he was mad, and he was right above me, right close to me. And I'm feeling a little afraid, and I tried to move, and I could not move a limb. I couldn't move my head. I couldn't move my body. Nothing was responding. Just this message I was getting.
According to Sanderson, the person who collided with him was actress Gwyneth Paltrow. In a 2019 lawsuit, he alleged that she skied away without offering help, leaving him with a concussion and long-term emotional and physical damage. Sanderson also said that a Deer Valley ski instructor who had been training Paltrow arrived afterward but hadn't seen the crash. Instead of helping, the instructor allegedly blamed Sanderson and left him there. Paltrow denied all claims and filed a countersuit in 2019 for a symbolic $1 in damages, stating that it was Sanderson who actually ran into her. Her legal team argued that she stayed at the scene until ski patrol arrived and that his injuries were either exaggerated or unrelated. The case went to trial in March 2023 in Park City, Utah. Sanderson testified about the lasting impact the crash had on his life, including memory issues and emotional distress. Paltrow also took the stand, firmly maintaining her innocence. After several days of testimony, the jury ruled in Paltrow's favor, clearing her of any fault. She was awarded the $1 she requested, along with reimbursement for legal costs. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.